Inc. versus Ken Paxton in his official capacity as Texas Attorney General, and Jennifer Cobos in her official capacity as Director of Regional Operations and Strategy for the Office of the Attorney General. This proceeding is being conducted via Zoom, as stated in the court's order, and noting that there was no objection, the court will proceed. The announcements, please.
Good morning, Your Honor. Jerome Wesovich and Peter McGraw, Texas Rio Grande Legal Aid for Plaintiff Annunciation House.
You're muted, sir.
Thank you, Judge. This is Rob Farquharson and Levi Fuller on behalf of the Office of the Attorney General and the state of Texas.
Okay. Good morning, everyone. And I believe some of the things that I discussed right now were off the record, so I want to make sure that it's all on the record. I want to point out that this matter was set originally for an in-person hearing. However, as a result of the logistics and issues involved for all the parties and for the court in terms of setting up this hearing in person, primarily security concerns and personnel, the time and use and expense of personnel, the court decided that because this is primarily a hearing where I will be hearing the argument on all the pleadings that have been filed, that this will be conducted via Zoom. I requested the parties contact the court by 4 p.m. I believe it was last Thursday. And I know in my order, I noted that we did not hear from the state. I have looked at the estate's motion to clarify the court's order dated June 13, 2024, objection and request for ruling, which was filed on June 14th at 3:59 p.m. I just saw that this morning, but I've looked at it, I've read it, and I guess the issue I want to address is this. In that motion, you have an exhibit that shows an email to the court. I want the record to reflect that I've had, we were waiting for a response that day, never received it. I've had my bailiff check his email. He has he never received that. I don't know why. We're not going to delay today's hearing to investigate that, but we will be looking into what happened there. It could be just good old, technology problems, or maybe there's something else, but we will address that. In any event, in your email, and please forgive me, Mr. Farquharson.
Yes, Judge. Hey, that's as close as most people get.
All right. I really don't want to butcher your name, so I will keep trying. The issues that you raise in that email is that you wish a ruling on the admissibility of evidentiary exhibits attached to the state's application for temporary injunction. That's one issue. The other one is order the parties to disclose any live witnesses that they may call by 4 p.m. I did not anticipate, still do not anticipate any witnesses. This is strictly a hearing on the motions, which are substantial, so that's what I want to hear. But if there's an issue regarding that, we'll address that. But here's the bigger issue. And then there was an objection filed by the plaintiff regarding let me see, where is it? I have a lot of paper, counsel. And I didn't print it all, but I printed the ones that I really wanted to address. Maybe I don't have that one in front of me. Great, I think I left it on my desk. In that event, it was the Annunciation House's objection to the temporary injunction. But as I read that motion and to address the issue raised by the state, obviously the plaintiff is objecting to the court granting the temporary injunction, but I did not interpret anything in that motion to say that I cannot hear it. Regardless of what you all's intent was, the court will hear all of these motions that are on the docket, 3 motions by the state and the motion for summary judgment by plaintiffs. And so rather than take up any more time, the order might matter in a different circumstance where these hearings were set for hearing on different dates, but they're going to be heard all at once by me. And so I don't think that the issues that we might have procedurally, if they were being heard on different days, would really matter. So what I'm going to do is I'm going to go ahead and hear Everybody's addressing the same issues, sort of coming at them from a different perspective, but ultimately the same issues are being addressed. So the state filed their motion first, so I'm going to go ahead and hear the state's motion. So you may proceed, Mr. Farquharson.
Thank you, Judge. So I think that there is significant overlap, as you just discussed, between the motion for leave and temporary injunction. And so I'll do my best to kind of coalesce those two to expedite today. Before we begin, I do want to offer a few items of evidence that we've sent some exhibits via email to the court coordinator and the court reporter, as well as opposing counsel. Has the court had an opportunity to receive those?
I believe I have, but I cannot tell you right now because I've received so many documents in this case, but I believe I have. And ultimately, if they were filed, they should already be part of the clerk's record.
Okay. So the documents that we would like to offer into evidence are, the first one is the transcript of Mary Bull. It is marked as State's Exhibit number 1. It is Miss Bull's deposition from April 17th, 2024. This document has already been offered by the Plaintiff Annunciation House in their motion for summary judgment, so I don't think there is a dispute as to admissibility. And so that would be our first document that we would offer.
Mr. Wesovich, any objection?
No, Your Honor.
It's admitted.
The second document that we would offer is the transcript of the hearing on March 7th, 2024 on the temporary injunction. Again, this document has been offered by the plaintiff as part of their motion for summary judgment. And so I don't think there is a dispute as to that document either.
Mr. Wesovich?
No objection, Your Honor.
That's admitted as well.
To be sure, I just for a clear record, if I didn't say, that is State's Exhibit number 2.
You did, but I always appreciate clarity. Go ahead.
And may I clarify one thing as well? That attached to that March 7 transcript were 2 exhibits that were admitted into evidence at that March 7 hearing. And the state only sent us its proposed exhibits a few seconds ago, so I haven't had a chance to review those. I just want to make sure that those 2 admitted exhibits are part of the evidence that the state includes in the March 7 transcript.
Counsel?
They're the transcript as it was given to us, and the same transcript that as I have reviewed it appears to be attached to the motion for summary judgment.
All right, so the court will admit the transcript with the 2 exhibits. If for any reason they are missing, we will notify the party so that you can provide them, but I'm sure we have them.
Thank you, Judge. The next exhibit is the State's Exhibit number 3. We would ask the court to take judicial notice of the governor's declaration dated May 31st, 2021.
The court will take judicial notice of that.
Thank you, Judge. The next is State's Exhibit number 4. What is marked as State's Exhibit number 4, and this is a March 2023 Annunciation House newsletter that was produced by Annunciation House, and we believe is self-authenticating. And so we would offer that at this time.
Mr. Wesovich?
No objection, Your Honor.
It's admitted.
The next item is what is marked as State's Exhibit number 5. It is a El Paso Matters article, and it was offered as evidence by Annunciation House, and we would offer that at this time.
And what is the date of that article?
January 20th, 2023.
Any objections?
No, Your Honor.
It's admitted.
Just three more here. The next one is what is marked as State's Exhibit number 6, and this is a New Yorker article. The date of the article is February 23rd, 2024. Again, this document has been offered as evidence, as summary judgment evidence by Plaintiff Annunciation House.
Any objection?
No, Your Honor.
It's admitted.
The next one is what is marked as State's Exhibit number 7, and that is the Declaration of Taylor Levi. This has been offered by as summary judgment evidence by Annunciation House, and we would offer it at this time.
Any objection?
No, Your Honor.
It's admitted.
The last one is the graduate thesis of Levi Taylor, which is marked as State's Exhibit number 8. This too was offered as summary judgment evidence by Annunciation House.
Any objection?
No, Your Honor.
It's admitted.
Thank you, Judge. So, with respect to a temporary injunction, there's 3 parts. The state needs to prove a cause of action against the defendant, a probable right to the relief sought, and an imminent and irreparable injury in the interim. With respect to a cause of action, the Attorney General has pled his authority under the Texas Constitution, Article 4, Section 22, the Texas Government Code, and then with respect to substantive allegations, as the court is aware, we're bringing a claim under Penal Code Sections 20.05 and 20.07. The second element that we need to prove is a probable right to the relief sought. It's important here that probable right to the relief sought, some appellate courts have called that a term of art in the injunction context. And so what the courts say is that in order for us to prove a probable right to the relief sought, we must plead a cause of action and then present some evidence that tends to sustain that cause of action. And I can give you the site here. It's 354 Southwest 3rd, 887. It's Intercontinental Terminals versus Vopak. The importance that I see of this is, as that court said, it said the temporary injunction is not a mini trial wherein the evidence is predicted and the ultimate outcome is predicted. The question is, did we plead a cause of action and did we present some evidence to sustain that cause of action? With respect to statutory entitlement and substantive legal violations, I've just named the statutes and the authority for those. The substantive legal violations, the elements of that are for illegal alien harboring under Section 20.05 of the Texas Penal Code. A person must knowingly encourage or induce a person to enter or remain in this country in violation of federal law by concealing, harboring, or shielding that person from detection. With respect to knowingly, I don't believe this element is disputed based on the response to the opposition to the state's motion for leave. As I read that, Annunciation House admits that they publicize their willingness to shelter people regardless of immigration status. Annunciation House also publicizes that they are the primary receiving site for people who have fallen from the border wall. With respect to the second element, encourage or induce a person to enter or remain in the country in violation of federal law, I believe that is also shown. I don't believe that's in dispute. Annunciation House, again, in their opposition that was filed last week, expressly said the federal government knows that undocumented persons reside in the Annunciation House. Annunciation House publicizes its willingness to shelter immigrants, and yet the federal government does not prosecute Annunciation House. The third element is by concealing, harboring, or shielding that person from detection. This is where the rubber meets the road. This is where the dispute is for the parties. And the dispute is based on, as I understand it, Annunciation House's reading of some language from Cruz versus Abbott. We believe that the evidence demonstrates concealment, harboring, and shielding because Annunciation House denies entry to law enforcement without a reasonable expectation of privacy. Annunciation House withheld documents pertaining to illegal aliens based on frivolous and pretextual objections. And because Annunciation House does not comply with document keeping requirements relating to the Emergency Food and Shelter Program, which require Annunciation House to maintain daily logs of the migrants that they serve.
Well, let me stop you there. I guess I want to understand this. Are you saying that Annunciation House, regardless of what they do and who they're housing or harboring, to use your language, are you saying that they have a diminished Fourth Amendment right?
Well, I think corporate entities certainly don't have the same expectations of privacies as people, if that answers your question.
Well, let's look at it in terms of homeless shelters. I mean, are you saying that law enforcement has the right to go into any homeless shelter without regard to the Fourth Amendment rights of the organization and the residents that are living there?
I think that would depend on the facts of
the reason I'm asking that is because to get to the issue of harboring and this last prong that we're discussing, what we're really trying to discuss and what I guess the court really needs to decide is, what does it mean to conceal? I mean, it seems from the record that I have before me so far that law enforcement knows what they do. So that's certainly not being concealed. And they certainly know or are aware of what they do. And so that, however, does not necessarily give them the right to just go in without a warrant. And that's really what I'm trying to get at, because if your argument is that they don't let people in, well, I'm not going to let people into my house. I don't think you will either, just because they suspect or they have suspicions. So absent a warrant, which is what our Constitution holds very dearly, is something that's going to be required in those circumstances. But anyway, go ahead. I'll let you continue. Those are some of the questions I have, so I want to give you an opportunity to address them.
Thank you, Judge. The only item that you just hit on that I think we would dispute is law enforcement knowledge. I don't know. We certainly do have opposing counsel's representations in their filings. I don't know that we have evidence of law enforcement's knowledge. The point that I'm making here, beyond law enforcement entry into Annunciation House, is record keeping practices. Is that there are records that were requested, and there was objections that were made to prolong the withholding of them. And those objections were, in some respects, completely abandoned. And with respect to the Emergency Food and Shelter Program, documents are supposed to be kept, and they're just simply not kept in violation of the rules of that program. And then with respect to the final element, irreparable and imminent injury, where a statute or a constitution provides for injunctive relief, this is satisfied as a matter of law. Here, the Texas Constitution, Article 4, Section 22, authorizes injunctive relief for the Attorney General against corporations that are violating the laws of the state. The case site for this is City of Wink versus Griffith Amusement, 129 Tex 40, TEX 40. And as a case, there's another case that's more express in stating that it's satisfied as a matter of law, and that is 8100 North Freeway Ltd. Versus the City of Houston, 329 Southwest 3rd, 858. And the reason that I said at the outset that the motion for leave and the temporary injunction substantially overlap is for the motion for leave to be granted, we need to plead a cause of action. It's really just whether or not did we plead a cause of action or did we not. And if we did plead a cause of action, the court accepts as true the allegations therein. And so the only difference between the motion for leave and the temporary injunction is the next question, and that is, did we present some evidence to sustain our cause of action? For the reasons that I've just explained with respect to the temporary injunction, the state has proven its entitlement to a motion for leave and a temporary injunction. And with respect to the plead to the jurisdiction, that's kind of a not natural segue. And so I think maybe that's best addressed in response to Mr. Wesovich's summary judgment filing.
No, I'd like to go ahead and hear it now. And then obviously if there's rebuttal that's needed, I'll allow you that opportunity.
Okay, thank you, Judge. Well, with respect to the plea to the jurisdiction, we believe that on the claims and the parties and the facts of this case, the court does not have jurisdiction to entertain Annunciation House's claims against the Attorney General. And to note, the state is an intervener in this lawsuit, but they are not a defendant. But the state is not a defendant.
Okay. Thank you.
Thank you, Judge.
Mr. Wesovich?
It's difficult for me to say anything else, Judge, other than what you've been just told is utter nonsense. The state claims that they have pleaded a cause of action under the Texas Constitution, Section 22, when they've pleaded no such thing. The court has of all the papers, the stack of papers that the court has in front of it, there's nothing that says that they have a cause of action under the Texas Constitution. They've provided no authority saying that they have a cause of action directly under the Constitution. They say that you've been told that, well, the Attorney General claims a cause of action under the Texas Penal Code, Sections 20.05 and 20.07. But the Court of Criminal Appeals only recently ruled that the Texas Attorney General has no authority to prosecute criminal offenses. Where is the cause of action? There's no pleading that says that. There's no authority that says that there's a cause of action. The only cause of action, the ground on which the Attorney General deliberately chose to fight was on this quo warranto procedure, this ancient procedure that's rarely ever used. That's the pleading that the court has in front of it. That's the only cause of action that is pending before the court. That is why the Annunciation House painstakingly went through why quo warranto is unavailable to the Attorney General in this case. And I'm happy to step through all the reasons why quo warranto is unavailable. But I first before I do that, I want to step through all of the misstatements that the court was told. The court was just told that, Annunciation House has admitted violating, that it didn't keep the records that are required by the Emergency Food and Shelter Program that's under FEMA. Well, admitted into evidence is the transcript from the March 7th hearing in this case. The court can see from the transcript that there's been perfect compliance with that program. Not only that, but in the privilege log that was admitted into evidence as an exhibit at the March 7th hearing, at the privilege log in that, it shows that Annunciation House provided to the Attorney General a waiver to the federal government, allowing the Attorney General to ask the federal government, you tell me independently, the AG could go to the federal government under FOIA independently and say, has Annunciation House complied? yet they offer no evidence. There's no evidence before the court that there's been any noncompliance with the emergency food and shelter program document requirements. That you were just told that there is no evidence, I think this was the quote, there is no evidence of law enforcement knowledge of what Annunciation House does. At the March 7 hearing, Ruben Garcia, the executive director of Annunciation House, went through point by point the many instances in which not only have federal and local authorities gone to Annunciation House to investigate people who were of interest to them, but also that they have delivered the Homeland Security investigations, the FBI. These agencies have delivered undocumented people to Annunciation House for witness protection or for their other purposes. Law enforcement is perfectly aware of that. There is no dispute in the record about that, yet you were told the exact opposite. You were also told that corporations don't have the same Fourth Amendment rights as persons. But you weren't told any authority. No authority was cited. They have never cited any authority because it's not the law. Corporations have Fourth Amendment rights. This gets us back to this whole idea of I want to go now into quo warranto and why that procedure is unavailable to the Attorney General, as he claims in his quote, in his only pending cause of action, and why the court should deny the Attorney General leave to file the counterclaim in quo warranto, so that they have no cause of action that's pending in the court, and the temporary injunction should be denied on that ground alone. Here's why quo warranto is unavailable. Elon Musk leaks some rocket fuel on the launch pad down in Boca Chica. He's violated the law. Can the Attorney General go in and say, hey, you violated the law. We're shutting you down. Your business is closed. All the investment that you've made in the facility down in South Texas, you got to move it somewhere else because you can't do business in Texas. Is that really what is quo warranto really that broad? If AT&T drivers go and get parking tickets, can the Attorney General really go in and shut down AT&T's operations in Texas? That is how broadly the Attorney General is claiming that he can enforce quo warranto in this case. There is a doctrine that prevents such vague statutes from being applied the way that the Attorney General is trying to apply quo warranto. Where a statute allows for selective prosecution because it doesn't advise people of when quo warranto can be used. And an indication that the statute does not inform people about when quo warranto can be used is that it's not used. Find any recent case where quo warranto has been used. And there are precious few instances where the doctrine has been invoked, and it's never been invoked this way, where there's been no conviction, there's been no clear proof of any violation of law, that there's a disputed interpretation of whether any violation of criminal law has ever even occurred. There's never been any close case where quo warranto has been invoked this way. It is the Texas legislature recognized this problem. And in 2003, the Texas legislature passed a law that said when corporations may be closed due to criminal activity. And that statute appears in Texas Business Organizations Code 11 11.301 or A5. And the statute says that to close a corporation in Texas, you need a felony conviction, evidence of persistent violations of felony law, and a indication that the violations will persist unless the corporation is closed. All three of those need to be proved before you can close a corporation. That statute passed long after the Quo Warranto statute. The Quo Warranto was 1985. This was passed in 2003. It supersedes the Quo Warranto statute. The newer statute that's more specific supersedes the earlier statute. There's a case. It's J&J. Let's see. Let me get the site for the court as you've been given sites. Let's see. We are. This is 810 Southwest 2nd, 859. In J&J Beverage, basically a convenience store clerk sold beer to a minor. Texas law said if you sell alcohol to a minor negligently, your license can be suspended. Texas law also said if you sell beer to a minor intentionally, then your license can be suspended. There's an obvious conflict between the statutes. The court said the more specific statute controls. You must prove intentional conduct because this was beer. This was not alcohol generally. Because it was beer, because there were two statutes on the same subject, the later, more specific statute controls. That's exactly what we have here. The legislature prescribed how corporate conduct is to be policed for violation of criminal law, and it gave very, very specific requirements that the Attorney General cannot begin to meet here. Instead, he wants to go back to an unused statute and give the court his own interpretation of the statute. Instead of Quo Warranto, the Attorney General must comply with 11.301A5. And one indication of the need to comply with that statute is that the Attorney General himself cited that statute. In the document that he filed on February the 16th, in paragraph 1, he points to this statute. Another reason, beyond the vagueness of Quo Warranto, beyond 11.301, there's a very important religious reason why the Attorney General is not allowed, is precluded from using Quo Warranto in this case. The Texas Attorney General under Texas Business Organizations Code 20.002C3 plainly has the option of seeking declaratory or injunctive relief against an organization rather than closing it. The option exists as a matter of statutory text. Because the Attorney General has the option, he is required to use the less restrictive option because of the Texas Religious Freedom Restoration Act. That act provides that a religious organization, their free exercise of religion cannot be substantially limited by the government unless the government uses the least restrictive way to do so. There's no legitimate dispute that Annunciation House serves undocumented persons as an expression of the Catholic faith and Jesus' command to love one another, no exceptions. There's no genuine dispute about that. The summary judgment briefing proves that, to which the Attorney General offered no evidentiary response. That is an undisputed fact. Does closure of Annunciation House substantially burden Annunciation House's practice of religion? That should be obvious. So the only question is the Attorney General using the least restrictive means available to address any concerns that the Attorney General has about Annunciation House's operations. And closure is not the least restrictive means. It's getting declaratory injunctive relief. That's Texas Business Organizations Code 20.002C3. Because the other options are available to the Attorney General, he is not allowed to use quo warranto. I would submit that if religious freedom does not allow Annunciation House to obey Jesus's primary command to love one another by providing a child a safe and warm place to sleep on a cold night, then there is no religious freedom in Texas.
Thank you, Mr. Wesovich. Any reply to that, Mr. Farquharson? You're muted.
Always forget to click that off. No, Judge, we would just refer the court back to our pleadings and the evidence that we've admitted.
Okay, thank you. Then with that, Mr. Wesovich, I don't know if it's going to be you or Mr. McGraw addressing the summary judgment, so I'll go ahead and hear from you.
It is our summary judgment. I began the March, it's me, Your Honor. I began the March 7 hearing in this case by saying that the Attorney General is not looking for documents. What the Attorney General is looking for is an excuse to close Annunciation House. Well, the facts after that hearing have only borne out what I said at the outset. The Attorney General's document request is not simply illegal, it's egregiously illegal. The Attorney General must have authority to request documents from anyone. The only authority that the Attorney General asserts is 12-151 and 12-152 of the Texas Business Organizations Code. Those statutes on their face do not afford people pre-compliance review. They just say that all businesses in Texas must turn over any documents sought by the Attorney General immediately. Well, in 2015, the Supreme Court looked at a statute like that, and it said, on its face, it's unconstitutional. It violates the Fourth Amendment. And by the way, Judge, contrary to what you were told in the beginning, all these cases that we're referring to, these Fourth Amendment cases, they're mostly about businesses. All the Fourth Amendment cases that we cite in our summary judgment motion, they are about businesses. And they require compliance with the Fourth Amendment as to searches of business records. So 1251 and 12152 are facially unconstitutional. The court can look that there's no pre-compliance review there. The Supreme Court said it was required. Texas and federal courts, that Supreme Court case is called City of Los Angeles v. Patel, and that case has been followed by federal courts and by Texas courts, and over again. On its face, this is a matter of law. That the sole statute the Attorney General relies on for his authority to request documents from an Annunciation House, that statute is unconstitutional. That is appropriate for summary judgment. It is a question of law. Next is the fact that there was no warrant served on Annunciation House for documents. There's no dispute about that. That's an undisputed fact. And it's also undisputed that the Attorney General's only stated grounds for seeking documents from Annunciation House are his alleged investigation into criminal activity. Well, warrants are required to investigate criminal activity. The Attorney General can't use 12-151 and 12-152 as an end run around the Fourth Amendment's warrant requirement. That's a second independent ground for why the request to examine the document request from the Attorney General is illegal and unconstitutional. Third, the The Attorney General is required, the Fourth Amendment, it has a warrant requirement and it also has a reasonableness requirement. All searches must be reasonable. Administrative subpoenas, there is a standard under C versus City of Seattle. The Supreme Court set a standard for the reasonableness of administrative subpoenas. And the burden of proof of reasonableness belongs only to the Attorney General. Annunciation House has no way to prove, has no access to evidence of whether the document request by the Attorney General is reasonable. The only person with that evidence is the Attorney General, and the Attorney General bears the burden. And that is why we filed a no evidence motion for summary judgment, because the law is clear that the Attorney General bears the burden on this element. We specified the element, we filed a no evidence motion for summary judgment on it, and the Attorney General responded with nothing. So that is so we have the unconstitutionality for absence of pre-compliance review. We have the absence of a warrant. We have the absence of proof of reasonableness. Then we get to retaliation. Annunciation House claims that the record is clear that the reason that the Attorney General demanded documents from Annunciation House was to manufacture an excuse to close Annunciation House. Texas Business Organizations Code 12.155, it does provide for closure of a business for any failure to provide documents. That's why we challenge the constitutionality of that statute, but it's also very clear that that was the Attorney General's intent. He wanted to be able to use 12.155 against Annunciation House. Even though Annunciation House made every effort to comply with the request to examine. The request to examine, the Attorney General will agree, listed 8 types of documents that the Attorney General wanted. Annunciation House provided documents in response to items 2, 3, and 4, and provided a privilege log as to the remaining ones, exactly as instructed against in the RTE. Yet even though the Annunciation House tried to comply with the Attorney General's document request, the Attorney General still went to the press, still tried to close Annunciation House, still tried to make unfounded accusations against Annunciation House in the press. The bottom line is the Cruz case. Mr. Farquharson was very correct in asserting that the Cruz case is why Annunciation House believes that nothing that it does is against the law. The Fifth Circuit is the law. The Fifth Circuit decided that merely providing shelter to undocumented persons is not a crime in Texas. Period. The Attorney General can point to nothing that Annunciation House does that is inconsistent with Cruz. The last reason why the Attorney General's document demand is illegal and unenforceable is because of another religious protection act that the Texas legislature has enacted. The Attorney General demands compliance with all these statutes. So even the Attorney General lists all these statutes with which it wants Annunciation House to comply. But it ignores one important statute that begins notwithstanding any other statute. And this is Texas Government Code 2400.002. This statute begins notwithstanding any other statute. Regardless of all the statutes cited by the Attorney General, the Attorney General is not allowed to take any adverse action in whole or in part against an entity based on its support of a religious organization. Annunciation House supports the Catholic Church by living the Catholic Church's values. That is support for the Catholic Church. It attracts people to it. It is the kind of thing that attracts people to the Catholic Church, that interests them in the Catholic Church, is the best of the Catholic faith. That is what Annunciation House does to support the Catholic Church. And that is exactly why the Attorney General chose to serve the document demand on Annunciation House. And that adverse action is explicitly prescribed by 2400.002. The Annunciation House needs the court's analysis of all the reasons why the document demand that the Attorney General made on Annunciation House is illegal. The reason that Annunciation House needs the court's analysis is because of the threat of future document demands. If there are future document demands, Annunciation House does not want to repeat what we've endured over the past 4 months. All of the litigation, all of the depositions over an 8-point document demand. Instead, the law ought to be very, very clear about what the guardrails are under Texas law for what document demand, what the Attorney General must do to demand documents from an organization. We have thoroughly studied the law and set forth what the law requires, and we would ask the court to enter a declaratory judgment that avoids us from having to come back here or anywhere else into a court to relitigate these same types of issues if the Attorney General wishes to investigate Annunciation House. Annunciation House does not assert that the Attorney General has no investigative authority or cannot investigate Annunciation House. No, the Attorney General can, but there are laws, and the Attorney General must respect those laws and has tried very hard to get around them at every juncture in this litigation. And that's why we seek the court's declaratory relief for Annunciation House that specifies what not only Annunciation House's rights and responsibilities are, but also what the Attorney General's rights and responsibilities are. Annunciation House also seeks permanent injunctive relief. Well, it's permanent in the sense that until good cause is shown, the injunctive relief would remain. And the injunctive relief wouldn't prevent any investigation of Annunciation House. All it would do is ensure that Annunciation House had adequate pre-compliance review prior to any enforcement of any future document demand and avoid this kind of litigation in the future. That is the summary of Annunciation House's summary judgment motion, Your Honor.
Thank you, Mr. Wesovich. Mr. Farquharson.
Thank you, Judge. The state would just refer the court to our responsive pleadings on the motion for summary judgment. We believe this was moot. We believe the court's order dated March 10th mooted the RTE issue, and we would re-urge our plea to the jurisdiction.
Okay. All right. Well, then with that, is there anything else from any of the parties?
Nothing from the state, Judge.
All right. Well, I want to thank you all. You've kept me busy, and I will be busy for the next week or 2 weeks. There are a number of issues that were raised here that were addressed in the pleadings, but that, as you've argued them, require me to go back and revisit and look at it a little more closely. So I would expect, and I will do my best to get something to you sooner, but expect a ruling on this in 2 weeks, by the end of 2 weeks. Okay?
Thank you, Judge.
All right. You all have a great day.